Mr. Booth, if you want to go ahead and come up here, you can, we'll start the timer as soon as you get started.
Thank you, John. Seems like more times I'm in front of you, the closer I get.
It is intimate here.
Yeah, to kind of do a makeshift.
Well, we're all friends, Mr. Nelson and I. Number,
Well, I was gonna say, I think you two have been opposite each other.
even when we were partners.
It's probably, yeah, even when you were partners.
I digress. Thank you, Your Honor. This case rubs, of course, against the abuse of discretion concept, which is our biggest guide stone when it comes to decisions that are apt for mere property. But it breaks the banks of that fairly quickly, starting with the idea of how things were structured in the pretrial order. And the pretrial order, of course, is so controlling that you can usually take a pass on comments made like everything should have been split in 2005, et cetera. And that was actually counsel's choice. They didn't go back and rebut and talk a lot about what happened in 2005. And there were several good reasons for that, including one that is predominant, and that is there was no evidence presented about what happened in 2005. All we know really is that the parties went from cohabiting to not cohabiting. A lot of talk on Mr. Chapman's choices and his disclosures. Not a lot of talk in the decision about what Mrs. Chapman thought about the whole thing, other than she didn't want a divorce. And when he filed for divorce, they worked through it and they didn't do it. They didn't split up the property. They had separate property as far as what we call separate property before the filing of a divorce. And they had commingled property, namely that Raymond James account. And when you take the Raymond James account, it was a joint account. The court made a specific finding that there is no basis for. The finding was that she was the sole contributor to that joint account. He testified that he had put in some 150,000, I'm using round numbers, early in the days. Remember, this was a 20-year marriage. Yes.
When did he put in? I was trying to see the evidence specific to that account. There is evidence of deposits in the account, but none for that deposit.
So far back in time that it predated when her expert was able to get documentation. It was his testimony that she never rebutted. She had a rebuttal for other transfers and said, I never saw a deposit for this or that. They all predate this. And that also just belies this.
He's an expert though too, right?
Right.
Did his expert find that deposit?
No, they both followed the pretrial order and they were all looking in 2021, 2020, around the time of the filing and trial. So nobody was doing archaeological surveys to try to find out what was happening back then. But what we have here is he at least testified that there was a contribution. She didn't contradict that contribution, that early contribution. And beyond that, it really doesn't matter. As a couple, going back to the idea that we have separate property while we're still married, as a couple, they chose to make this a joint account. And, we've all been in the conversation where somebody's individual account, a 401k or an IRA, those were all contributions by myself. Well, of course they were. You and your employer got together, created tax consequences for that. And it's always just in one name. But there's nothing in a 20-year marriage in which we put things together when we cobble it together on the filing of the divorce that says that just because you robbed Peter to pay into your 401k doesn't mean Paul got a little taken away from him too. And so, we just hold no quarter for the idea usually that one person over a 20-year marriage contributed everything to a particular account when it was marital resources. We constantly, and I'm demonstrating this over and over again, and what I'm sharing this morning, we're constantly dancing between this contradictory stance that we have in the law, which I think is a very healthy one, that says married people have individual property and individual rights, and their spouses can't take their money, nor can their spouses' creditors. But when we go to looking at breaking up the marriage, we see it as a community effort, and we bring things together. that's the point in which we're most together, is when we're trying to get the furthest apart. So it's an interesting little contradiction, if you want to call it that way, or a way that we do equity.
I know one of the issues is, did she change the valuation date from 2021 to 2005?
Yes.
Would it make it, does it all come out in the wash, so to speak?
No, because you're making decisions. First of all, you're making decisions and dividing an estate you know nothing about.
Mhm.
We don't have a value for the Raymond James account at the time of the 2005.
But when the parties can't reach an agreement as to how to divide their property, you turn it over to the judge
Right.
to make the best decision he or she can make based on the evidence before
Right.
them.
And that's,
So ignoring which valuation date was used, what was untoward about her final outcome?
contradicted her own evidentiary findings.
Mhm.
She said the basis for her for Sharon getting all of that Raymond James account was that she was the sole contributor. And at the same time, in the same document, she acknowledges that he enriched that account by $500,000. We skip between the two dates. Somehow we get amnesia when we go back to 2005, but you can't ignore the fact that the couple treated that as a trend and treated it as their account. He's living in Kansas, Missouri. She's living in Johnson County, and he's working the account, increasing the value. And she testified that she often had no idea what was going on in those accounts. Talk about trust. Talk about liability of
This is
very
the most amiable split in all other ways, I think.
yes,
I've ever
yes,
seen.
very, very intelligent, caring, compassionate people.
Isn't it true, though, that we don't have to divide this account equally? We don't even have to divide it by what each of them put into it.
As long as we're not arbitrary,
Right.
capricious,
Yeah.
yada, yada, yada.
At the end,
Yes.
we have a reasonable division of property, right?
Equitable.
Equitable, reasonable under the circumstances.
Certainly. And you can't come up with an equitable distribution if you don't know what the parts are. Here we're painting with such a broad brush that we really have no idea. And then it spills in when you look at the trailing issues, including the fact that the court charged him for the taxes on the account she set aside to her. She testified the right thing to do would be for her to pay for the taxes. But the court, even on reconsideration, didn't charge her for her own taxes on her own account, but she supposedly was the sole contributor to. It's as though the court blamed him for making money in the account and charged him for the costs of making that money.
Well, is there any credibility and sort of blame that is permissible to go into the district court's decision?
It's so limited because it's not dissipation, and that's our main thing.
Mhm.
The dissipation of assets has its own set of criteria, and if he was accused of anything that was untoward, it's that he parted company and moved over to Missouri after declaring that he was gay.
Purchases, weren't there some purchases?
There were some purchases, a number of things that they bought back and forth. Lots of attention on whether or not he used their joint account. Remember, it's their joint account, so why would he have any idea why he was doing one thing or the other?
It seems like that became the heart of the disagreement, is when he was buying properties and she didn't know it. Is that,
That was a big
it seems like everything's
flag.
pretty agreeable.
But if you look at it this way, he was not using the Raymond James money to buy the property. He was using his inherited. And he's sitting in Missouri. If he would have moved that into joint, it would have converted to joint. If he would have suffered a Missouri divorce, he wouldn't know. He's a lawyer, so he might think about it, but he wouldn't know. In Kansas, we're going to trace that equity a little bit more equitably, which is the counterside to exactly the issue you just raised.
Mhm.
But there was nothing wasteful about instead of having Apple stock, having condominiums, et cetera. And the only thing that wound up at issue there was the condominiums had the tax and HOA loans against them, which he rightfully argued, if you're going to net out what these assets are. So here we have netting out of these assets and blame and conversation for 2005 to 2021. conversations. And that's all loading this decision that says we're going to forget about all that. They apparently parted company in 2005, which wasn't true.
Did
But-
they actually, I mean, when I look at the numbers that were actually used for the values,
Mhm.
the court said, we're setting a value date of this. Okay, and then, sorry about that. They were actually the 2021 values, right?
Correct.
Okay, so the court didn't actually use a 2005 valuation date,
Well, it said it did.
right?
Okay.
So,
So the court said
and
things, sometimes I say things and that's not the word I meant. But the actual values that were used were 2021.
the spreadsheet was 2021. There was talk about assets after that, but when she awards Raymond James, she just basically sets it over as though he had no contributions, and therefore it was as though it was a premarital asset in 2021. And what we're looking at is litigating 2021 to 2025 instead of date of marriage, which was 20 years before that, to now. And this relationship isn't defined by which chapter, the two chapters being nearly equal, but the first half or the last half. All we do know is that he offered a divorce in 2021. They decided not to. I'm sorry, the earlier date, whatever that's,
Right.
05. And then they stayed married and vacationed, co-invested.
So what's the bottom line money wise? I mean, how much does he, I mean, it comes down to money. How much what's the total amount he believes he should have been given and wasn't?
Well, we don't know the value because it is the 2005.
No,
No,
use the
use
2021 value.
Yeah, use
Was-
the current.
If you divide it and award her the entire 2005 asset, or you can say the value
Let's
is,
assume she
21.
did it like you wanted her to
Right.
do it.
it would be the value of the Raymond James account minus her inheritance.
Which,
He would-
but how much are we talking?
It was 100,000. If I recall.
So $100,000 discrepancy is the case?
She inherited 100.
No, I know. I'm just saying if you had gotten everything you wanted.
You were faster than I was on the math.
Yeah.
300, 200, 100.
Yeah.
Gotcha. Yes. And then on top of that, we have this.
I just want a total, Mr. Booth.
Well,
What is your idea of what, if things if he had gotten X number of dollars, we wouldn't be here today. That's what.
It is the half of the Raymond James account, but
How,
Of the half.
minus 100.
Okay.
It is going back and ignoring this transfer and adjustment for the money that went into the interest-bearing account that was never proven to have ever gotten out of the.
okay, you have to know just what are we talking
Yeah.
about? I mean,
But he's got a debit against him for half that value of the, what was 375,000 that went into the high interest bearing in Schwab. He showed the exhibit 3D, I believe it was called, and he's still charged for half that.
so I'm going to ask it one more time.
Yeah.
So this journal entry
Right,
that Judge Mason entered,
right.
cheats him out, I mean, just of how much money? I just want the math, just the total,
Okay.
how unreasonable was this?
She got the entirety of the Raymond James and then.
Okay, I don't have those numbers in front of me. I just want you to,
Just a total,
Just-
just a total.
I-
You have to have some idea what you would want to happen when you go back. What should have happened?
Approximately $300,000 because it's built from three elements.
Okay.
And that is charging him for money that wasn't missing and they couldn't prove was missing and
Okay.
showed was there.
So she got $300,000 more and he got $300,000 less.
Yes, when you combine those,
Out of this. That's all I want to know.
and then on top of that, we have him paying her income tax to the tune of about $40,000 on her asset that was awarded to.
Okay, so.
You reverse.
340 now, we're at.
So but I need to back that one off in total candor, because if you split the Raymond James account, then the tax decision logically would be different too.
Okay, All right, I just want to ball,
pay all of her taxes if she gets all of the assets, if they
just
put the assets.
ballpark. That's all I'm.
Mr. Booth, please, for the love of, it all, just answer the question.
Yeah.
A number. I don't need it broken down.
I think we're right at that three,
About 300,
300?
around the
Okay.
300,000.
All right, just, thank you. I think you're out of
It's on my alarm.
I'll still give you your rebuttal because we started asking questions right at the end of your time. So, Mr. Nelson. Mr. Booth doesn't have any hair left. Mr. Nelson all has hair. That's what being a family law practitioner does to you.
Exactly.
You both have a special place in heaven.
True.
There are a lot of wild hairs in this case, and one of the wild hairs is the valuation date. Judge Mason used the valuation date that these parties agreed to and included in the pretrial order,
Which was which year?
which is 2021.
Okay.
We admit in the brief that Judge Mason misspoke. She said, I'm going to use the date of valuation as 2005. It's not what she meant. It's not what she did. She used that as the date of division. She said, the two of you separated in 2005. You accumulated things after that time. And you agreed to all these things on what to do with them, how to do what with them, and who got what. And so I'm going to deal with these issues that you have not been able to agree to, these properties and these particular matters. And she went through meticulously on each one of those and said, this is how I'm doing it. This is what I'm doing, and this is why I'm doing it. She ultimately put the division spreadsheet as an attachment to journal entry and said, given the division that I have said, this is how the numbers break down. That's unequal. That is disparate. It is widely disparate. That is my decision. Mr. Chapman requested that I divide everything equally.
Thank you.
Apologize.
Yeah.
Thank you, but just so you know, I think it locks, which is.
Yes,
don't
the
cut
Ms.
it all the
Jackson, if
way.
there's any way,
Yeah.
yeah, thank you. We learned yesterday that once it shuts, it locks and nobody
Lock
can
it.
come in. Okay,
Now I can't.
okay, I'm sorry.
Judge Mason said these are disparate
Yes.
and
And she understood that.
One of them-
She knew that.
Mhm.
And she said, that's my intention, to give a disparate division of assets.
doesn't sound like Mr. Booth wants an equal division. It
That
sounds-
is,
It
What-
sounds like he wants, because 300 grand extra wouldn't equal them out.
that's what they asked for at the trial court. That's what they asked for at the motion to alter or amend. That is what they wanted. That is what they have always said, is an equal division. And because Judge didn't give me an equal division, I don't think it's fair. I don't think it's appropriate. I don't think it appropriately divides everything. And that was the motion to alter or amend, was he brought the same thing to Judge Mason on the motion to alter or amend. And the judge said, I considered all this. I looked at all this. I paid attention to all of those things, and this is how I divided it.
Now, we're discussing this 2021 versus 2005. In all fairness, the judge did say more than once that the valuation date was 2005.
I did.
And so are we just ignoring that? I mean, how are we sure that it was the 2021 date?
Well, because that's the date that was used on all of her numbers, one on the spreadsheet, two elsewhere. And she said, I'm going to look at 2005 because that's when they separated and started accumulating their own things. Now, one of the things that Mr. Booth indicated, one of the things that was an issue at trial and afterwards was the talk about marital versus individual property. There's no such thing in Kansas.
There is no such thing.
There is marital property once the divorce is filed and everything is divided as the judge determines is fair, just, and equitable, given all of the factors in the individual case, and it can be widely disparate. It doesn't matter when the property was obtained. It doesn't matter how the property was obtained. It doesn't matter the value of the property. It matters whether the judge believes the particular division that the judge finally ends up with by agreements and by the court's own decisions, whether the judge looks at that and says, well, I need to adjust that, or, well, it's not equal, but it doesn't matter because that's what I think is fair, just, and equitable. And that's what the judge did. She didn't go back and say these values in 2005. She said each of the parties had various assets that they handled as their own after their separation in 2005. There was a joint account that she contributed to after 2005, and that considering everything, I'm going to give that to her. There were things that Ms. Chapman requested be divided equally or be given to Mr. Chapman, but the court said, no, I'm doing it a different way. I'm giving either Ms. Chapman asked that he be given something and the court divided it equally or gave it to her, or the other way around. So
The point is, the judge put a lot of thought into this. It wasn't just a rote.
it is not what I,
Now, this Raymond James account, I mean, at least for a period of time, he was taking a payment out of that account
he was.
as well. And was that calculated? The fact that there was already some that if we say that's all her account, he did get some benefit from that account.
Get some benefit from it. Because he was taking money out of the
And it
rent.
was all by agreement. I mean, it's
It was,
period.
it was all by, well, it wasn't necessarily by agreement, but it wasn't by it was over an objection. And
Well, I think she suggested it. She suggested,
Yeah.
I'm going to take 2,000 a month to supplement my income. And why don't you take 2,000 a month out of that account too? Okay,
and so there were, that was the specific account.
right.
But there were other
Right.
matters like that because she didn't want a divorce. She didn't want this marriage to end. She loved Mr. Chapman. She cared about Mr. Chapman
I think it's clear they both cared a lot about each other.
very much, very much.
I mean, this
And it
is
was-
amazing.
It was an unfortunate situation, but what the court looked at was, yes, this was an amicable situation. Yes, Ms. Chapman bent over backwards because she loved Mr. Chapman. And Mr. Chapman did all of this either without ever talking to her, and he didn't have to do that.
Mhm.
We don't have to do that in marriages. We don't have to talk to our partner about that. But she was fully open with him and he wasn't for whatever reason. And the court said, and Mr. Chapman, Mr. Booth, focus on, there's no dissipation. Dissipation's not the issue. There was no allegation of dissipation. In the pretrial order and from the beginning of the case, Ms. Tilges for Ms. Chapman said, this is the valuation date. This is the date of all of the things in 2021 when the petition for divorce that ended in a divorce decree should be valued. But everything should be divided as of 2005 when they started accumulating things And
She's saying I can't ignore the split in 2005 because that kind of um, uh, tells the story better. So,
yes.
but you're saying the actual valuation dates were 2021.
Correct. And that's what the court used on its valuation spreadsheet. That's what the court referred to throughout its opinion on values and other items. And Judge Mason discussed what happened with individual items
Mhm.
throughout her 39-page decision
Right.
and said, that's what I'm doing. That's how I'm
Justifying.
in this to my satisfaction of what is an appropriate and fair division.
In coming, in briefing this, how much money did you think was at dispute? Like if we were able to fix it exactly how we wanted and say this is the correct award?
I don't know, because our position is that the judge did just what she should have done.
I know, but you read their brief and replied to
Yes.
it. And so in doing that, how much more money do you think he wanted? You hadn't thought about it?
I hadn't really thought about it.
Okay.
Because there were so many parts of it that, not simplifying it, but nitpicking everything that wasn't his way, wasn't equally divided, wasn't divided as of the date that he wanted it to be divided, because he didn't want it divided in 2005.
Well, it wasn't divided as of the 2005 value, right? It was divided as of the 2021
Yes.
value?
Yes,
Okay, okay.
but it was,
The separation date was considered as a factor regarding the,
How they'd
how
intermingled.
they,
how it was to be divided, who was to get what, and what factors were to be considered as a result of that, and as a result of all the properties, the 8 condominiums that Mr. Chapman purchased, which goes to the taxes that were discussed, which Judge Mason specifically addressed and said, these are taxes for real estate. These are taxes that came out of that account. No, I'm not going to credit you, Mr. Chapman, with those taxes. Those were yours. And there are so many things like that Judge Mason looked at and did. Everything is addressed in my brief. Really, from our standpoint, it comes down to, there was a request for an equal division of everything from Mr. Chapman. There was a request of an unequal division as of a certain, starting as of a certain separation date, and then with the values looking at 2021 to see, okay, how does that line up? But Ms. Chapman never asked that final valuation be equal, and never considered whether it would be equal or not. It was how it's divided is what matters. And I'll stand on my brief for the other issues.
Yeah, time to write up.
Any further questions?
No. Big to try to challenge an abuse of discretion on a judge that has all of these different moving parts.
Right.
You agree? So why does this case, why did Judge Mason get it so wrong that she abused her discretion?
It was primarily in moving.
And do you think it's a legal error because the valuation date or okay?
Yes, most specifically, it's that. We went back and asked, it wasn't that she misspoke. She justified the reason for using the 2005 separation date by saying, when asked about the date evaluation, why did you move the date evaluation? Did not answer the procedural questions about how you move the date evaluation, gave people due process, just said everything went to that 2005 separation date. Just about the entire case was about separating in 2005 and what the parties did after that. That's Record on Appeal 36, pages 5 and 6. So she's saying, I purposely moved the valuation date to 2005. She used 2001 numbers to render a valuation date of 2005's decision. And from that, she had no evidence. None of the experts had anything. They couldn't find the records for it. There was very little testimony about what happened other than they no longer cohabited. This
There was testimony that, about this one account, that since 2005, the only deposits were from Ms. Chapman, right?
yes,
Okay.
that's post 2005, which is past the valuation date the court uses. The door is closed. Now we have chatter about what happens after that. It's filling in all this information on what to do with the 2005 valuation date, except for we don't have any value of the 2005.
Well, so doesn't that more lean towards she wasn't using it as a valuation date? She's just using that as a point in time to start gauging the party's conduct, just as Mr. Larson says, that we just want to see what their behavior was past that 2005 point. To me, if there's no evidence of anything that could be valued, that leans more towards that was her intention, not evaluation.
Well, she expressed her intention differently. You know, sort of like what we just had in a conversation, for the love of God, Hunter, why did you do this? And she said, because everything rolled back to 2005 and the entire trial in her mind was for what happened after 2005. I purposely changed the valuation date because I thought it was appropriate, missing all the rigor of 216.
Okay, so we agree, say we agree with you, and we send this back. She takes all the evidence, comes up with the same decision,
That's happened to me before.
right?
It's happened to me before.
All
But
right,
we may know why.
yeah,
You know, questions like, how does somebody contributing $500,000 to the other person's estate just get ignored? How does it just go away?
And that is the increase in value from
Right, that
his management,
he managed,
right.
nope,
except that you said you're not looking for $500,000.
we're splitting the account. And if you split the account, it includes that growth.
Right.
And the way we came up with that math was 100,000 was inherited. That leaves 2, which leaves 1 each. And then we talked about that double dip, the 300,000 for the cash account.
Okay.
That circles the story around pretty well. Other elements rely on this whole business of how the assets are split and what the load is against. If we're splitting all the assets, his load with the taxes and homeowners association for the condos gets a different flavor, and so does the income tax off of her Raymond James account that he wound up paying for, even when questioned by the court, over her sense of what was a fair or not. Sharon, I think I've about burnt my time up.
Yeah.
Yep, you have. Thank you very much.
Thank you.
Thank you both. Great briefs, great argument. We appreciate it. These cases are never, never easy.